Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. Last week, we began a fascinating discussion about what goes on in the critical window of time just after someone is arrested and what steps you might want to take or avoid taking if you are that person who's in that situation. Today, we look forward to delving deeper into the topic with our guest, criminal defense attorney Joe Marino III, who has lots more insights to share from the perspectives of both the prosecution and the defense.
What sorts of things can an attorney do at the earliest stages, just after arrest, to help build the defense and perhaps even avoid criminal charges from being brought? What are the pros and cons of waiting to see if charges will be brought versus getting a defense attorney involved just after arrest? What sorts of legal defense costs are involved? Our returning guest today is criminal defense attorney Joe Marino III, who joins us in just a few minutes.
And we are looking forward to continuing that conversation with him. But before we bring Joe back on, you know, sometimes people are arrested on the weekend. Sometimes they're arrested late at night. So does that complicate the situation in terms of reaching an attorney?
It certainly does. And I can tell you that I've been practicing for close to 25 years now, and I do a personal injury practice, claims against insurance companies, but my clients know they can call me for any reason, and I'll try and help them find an attorney if it's an issue that I don't handle. I get calls late at night. I get calls on weekends, and oftentimes it's a family member, friend who got arrested. And what I typically tell them is, listen, you're not going to be able, by and large, you're not going to be able to get a criminal defense attorney on the phone late at night. And for that matter, even if you could, that attorney can't get you out of jail. First thing in the morning, and maybe it's going to be first thing Monday morning if it's on the weekend, call the attorney, have all your information that you have available to talk to the attorney, and that attorney will get to work helping get your son, family member out of jail. Okay,
all right. Lots more to discuss with our guest, attorney Joe Marino. He joins the show next, so stay tuned. We'll be back after this. Hello, everyone. Welcome back to the show. Well, to all of you out there who are curious about what's involved with arrests and the charges that may come, or if you need guidance, if you have had a family member placed under arrest, or you just want to know for your own sake, well, we're happy to welcome attorney Joe Marino III to Power of Attorney to continue our discussion of what happens when someone is arrested.
Joe Marino has been a criminal defense attorney for many years, defending the rights of those charged with misdemeanor and felony crimes. Joe, thanks so much for being with us again on the show. A lot of ground covered and a lot more ground to cover. So we thought it would be helpful to do a step-by-step review of what it is that a criminal defense attorney such as yourself should do, in your opinion, if they're brought in at that early phase. You get the call from the concerned family member right after arrest, and you're able to meet early on, and you're hired. Help us understand, what's one of the first things you do? What do you do after that? Let's walk through it.
Right. Well, like we talked about in the last show, the first and most critical concern of the parent or spouse is, how do I get them out of jail?
Right.
So once we go through the setting of the bond process and get them released from jail, whether by personal surety or bail bondsman if necessary, after they're out of jail, there's a segment of time when the district attorney is going to be reviewing the charges. And then when you have an attorney early on, your attorney can immediately get involved with meeting with the prosecutors before they file charges. But the other thing that the attorney does very on, if you hired, at the early stage is, I want to talk to my client about, these are the elements of the crime that you're charged with. Do we have witnesses that I need to interview? Do we have evidence or information that I need to gather and put together to bring to the state to show the district attorney while they're in the review process? Because if you can get the charges dismissed or reduced before they're even filed, that's where the value of having an attorney immediately is.
Do your clients always disclose information? Have you ever been in a situation where, for whatever reason, a client doesn't want to give you all of the information for fear of what that might do?
Yeah, I mean, even after I explain to them an attorney-client privilege, there are people that think that if I tell the attorney that I did it or I did what I was accused of, then he's not going to defend me, which I tell the people, this is how this works. I need to know exactly what happened. I need to know everything that is going to be relevant to your defense, including whether or not you did or did not actually commit the offense. Because if you did commit a crime and there's evidence sufficient to prosecute you and convict you of that, well, my approach to defending you is significantly different. Then I'm working on mitigating the damage, trying to not make sure you don't spend a long period of time.
At that point.
Try to see if we can get you to probation or other programs or things that are available to you, which is a different way of approaching a case than if you have someone arrested and accused of a crime they didn't commit. So, but it's not uncommon for people to not initially want to disclose everything. So I kind of take the role of the prosecutor when I'm interviewing my own client to start asking them questions or follow up on what they just said. Well, what about, and I want to get to the truth, and sometimes the truth doesn't come out immediately.
Right, and there may be something that's very relevant to the case that the client doesn't think is relevant to the case, but by answering all of your questions, that just helps you and other defense attorneys prepare an adequate defense to represent that client.
Right. When I've been to enough pretrial conferences to know what's going to be discussed with the judge and know what the district attorney is looking for and know what the elements of the offense are to know how to guide them.
It's interesting, in the personal injury world, there's a bit of a parallel. The client really wants your help. They want you to believe that they deserve, to get off the hook, to not, and in the personal injury world, the client wants you to represent them and get a good result for them. And they might not want to mention that they had an injury 2 years before the accident they were just in. And so your job, it's like mine, I have to let them know, look, the only way this is going to work is if you trust me and you understand that I'm not here to judge you, I'm here to help you, and I'm here to do damage control if there's some bad things or things in your skeletons in your closet or bad things that might, even in your case, if they did it, then what can we do to try
advise you how to proceed
to minimize the harm? You might be able to beat the rap if the state doesn't do its job, dot every I and cross every T too. That's part of your responsibility as their lawyer as well, right?
I mean, once you're accused of a crime and they file the charges against you, at that point I'm able to get the discovery, which is the police report and basically a copy of the district attorney's file to see exactly what the evidence is against you. And there are cases where a person's committed a crime, but they don't have sufficient evidence to convict. They're missing parts of their case, but the decision whether or not you should proceed to trial or enter into a plea agreement or anything along those is something that's happening as the case is progressing. I can't tell you when you're first arrested whether or not this is a case that we should be trying to work out a plea agreement or we should be saying we're going forward to trial in the beginning. Yeah. Because you just don't have the information at that point.
Well, you have to figure out or decide who is going to represent you. And I know we touched on that a little bit during the last segment, or last show, but let's talk a little bit more about how to go about selecting a lawyer. Important that you get a criminal defense lawyer, right?
It's important to, just like if you go into a doctor, you don't want to go see a heart doctor if you've got a problem with your knee. And you want to find the attorney that handles that type of law, and more so, like I mentioned in the last show, in that jurisdiction. Because when I get calls when people want me to represent them in Baton Rouge or even in St. Charles Parish, the first thing I'll tell them is I've been doing criminal defense for a very long time, but I'm not familiar with that jurisdiction. I'm not familiar with their procedures. I'm not familiar with the prosecutors. I haven't appeared before these judges. So do you practice this line of this area of law, and do you have experience in this jurisdiction? Do you go to these courts on a daily basis? Do you deal with these judges?
Right. Well, let me ask the follow-up. Some people might think, well, wait a minute, does that mean if you don't practice in St. Charles Parish and you don't know that judge and those prosecutors, you're going to get hometown, or are you just simply saying the policies and procedures, the way the courts set up their own rules, how that court operates, puts you at a disadvantage? Or are you saying both things?
Well, I mean, it puts you at a disadvantage to have an attorney that's not familiar with the process, how they're going to do it, how they're going to handle your case, how they're going to review your case. About the particular judges, every judge is different. I mean, there are some judges that are much more harsher sentencing judges, and that's something that you need to know if you're going to advise your client whether or not they're making a decision to go forward to trial or not.
Mm-hmm. Yeah, and some
you
judges,
need to know.
Yeah, exactly. And some judges, the way they interpret the law, you can interpret the law to allow certain evidence in. Some judges can can be very liberal and say, I'm going to not allow the prosecution to allow this evidence in. Helps very much for you to know how this particular judge is.
And when you're making representations to the court in a pretrial conference, if that judge knows you and that prosecutor knows you and knows that you're not going to be in there trying to mislead them or fool them or slip something past them, then you're much more effective in dealing with that judge. Or you have someone else that comes into the court and they make representations to the judge. They don't necessarily know whether or not that's actually true and correct.
Well, you know, I'm glad you brought that up, and to both of you. I mean, how important is that you do have that sort of relationship with the judge? You know the judge, and the judge knows you. I mean, that could make a big difference in the case and how it goes?
Not in any unethical way, but
Right.
in a positive way.
Right.
Unless your reputation with the judge and with the other side is, don't trust this guy, don't trust this lady. She says she's going to give you the file, but then she never gives it to you, or the answers that you need.
Well, here's another way that I like to explain to people what the advantage of having an attorney that knows the judges and knows the prosecutors. If you have an attorney that has trial experience and jury trial experience and has won cases, has gotten people, won not guilty verdicts in the type of case that you're charged with, then the district attorney knows that this attorney can go to trial and will go to trial, and they will deal differently with that type of attorney, in my opinion, than they will someone who they know, that attorney pleads his clients guilty every time he comes to court.
That's an excellent example, and the same is true in my world. If they know you and they know that you have tried cases and you've won cases and you've been through every court, through the U.S. Supreme Court, they show you a lot more respect. They don't think they could take advantage. They don't think they could steamroll you, and
Right.
and when they negotiate with you on whatever the deal you're going to work out, you can count on a much fairer deal, and oftentimes you're in a much better position on behalf of your client. One more thing I wanted to add, we were talking on the break, attorneys.com is a reputable national company as a place to go find out more about your attorney, any attorney you're interested in checking out. Martindale.com is another national company. You can go there, but you can also check if the attorney works in a specific area of law, like criminal law, and
Right.
you can check the jurisdiction if that lawyer works in the area, in the parish where you're facing charges.
Right.
All
And
right. I'm sorry. Go ahead.
No, I'm just saying the peer review system is very good. I mean, those are attorneys that practice in that area, and judges rating attorneys on legal ability and ethical standards.
Okay, we have to take a break, but when we come back, we're going to get to your questions, so stay tuned. We'll be right back. Welcome back to the show. Well, we've been getting your questions all week long about arrests for our guest today, Attorney Joe Marino III. And so we're going to go ahead and get right to those questions. We have a question here about warrants. What if there is a warrant for your arrest? How can that affect the situation?
Right. A warrant for your arrest is generally that you've been, a complaint has been made and that the police have sufficient probable cause to arrest you and charge you with this crime. You may get a call from a police officer or a detective saying, we want you to come in for questioning. Again, like I talked in the last segment, that's the critical point, to have an attorney involved, to have an attorney with you to advise you whether or not it's in your best interest to cooperate or to not answer any questions, because I've done both. And if you have a warrant for your arrest, then that means that they're going to place you under arrest and take you to jail, but they may want to question you before they do that. It's very common for them to want to ask you questions, or to tell you, or they'll tell the person, well, we want to hear your side of the story, or tell us what happened. Again, you don't play around with a felony criminal charge without an attorney. It's just it's a game. Even if you are completely innocent you still don't want to go in and answer questions until an attorney advises you that that is in your best interest.
Okay. We have another question here about, let's say you decide to go through a bail bondsman, and the question is, are you able to get out as soon as you work with the bail bondsman, or do you have to wait?
There's always a wait, whether you post a bail bond or whether you do a signature bond or whether you do a property bond. There's pretty much the same processing time delays that take place. The jails move very slow, and even after your bond is posted, it could be 3, 4, 5 hours later before you're actually released.
Wow. But okay, so what if I am arrested in Jefferson Parish and I do post bail, but they find out that I've also gotten into trouble in East Baton Rouge Parish? What happens then? Am I going to be released? Am I going to have to be transferred? How does that affect the situation?
Well, I mean, sometimes you have that situation where you don't you're not only dealing with the bond or the bail for the charge you were just arrested for. You may have a hold for another jurisdiction for a warrant or a missing court, or you may have a probation hold. Once you post that bond in this jurisdiction, they'll notify the other jurisdiction if they have a warrant or a hold for you, that you are in their custody, and they'll make a decision as to whether they're going to come get you and transfer you over there or allow you to be released.
Okay. All right. Another question is, what happens during a bond reduction hearing? What is a bond reduction hearing?
A bond reduction hearing is typically filed when on more serious offenses, when the bond is very high and the family can't afford to post that type of bond. They don't have property sufficient to cover it, or they don't want to spend a large amount of money to pay a bail bondsman. Bond reduction hearing, you can present evidence or witnesses. The defense attorney can call the police officer, because one of the factors in determining bond is the weight of evidence. So if I want to go into why I think one of the reasons why my bond should be lowered is because they don't have any evidence to convict me of this, then your attorney can call witnesses and or police officers at that hearing.
So when you say the weight of evidence, you're talking about just how much evidence there is against you that supports you or shows that you are in fact, were involved in the crime.
Well, or also, if you're arrested for one offense, but you're trying to show the court that that's not the correct charge, or that's not, more likely than not, the proper offense should be a different or lesser offense, you can present that evidence to the judge as well at that time.
Okay, let's talk about overcrowding. What is overcrowding, and how does that affect the situation?
In Jefferson Parish, it's always a hot topic that you see on the news. They're talking about prison overcrowding.
Right.
All the time. I mean, the jail can only hold so many people, and when it gets to its capacity, they start releasing people on their own signature. Okay, they sign their own bond, and they guarantee that they'll appear in court. But I mean, generally, the overcrowding is going to take place with nonviolent offenses, first offenders, much lower grade offenses. They're not going to be releasing someone charged with armed robbery on prison overcrowding.
Okay.
They're not going to be releasing someone who has 3 prior felony convictions on their own signature, that type of thing. But when you're released on a signature bond, I mean, overcrowding, you're signing the bond saying that I will appear in court and you're guaranteeing your own appearance, and if you don't, you owe the money to the court.
Wow,
personally.
Okay. All right, well, I have a question here, is how long can a person be kept in jail after an arrest has been made?
Okay. If you don't post bond, there's different time periods depending on whether or not you're charged with a misdemeanor or a felony offense. But in general, with felony offenses, the district attorney has 120 days to file charges against you, and if they have not filed any criminal charges against you within 120 days, you can file a motion to be released without bond.
So you could be in jail for 120 days, depending on the situation, and if you are, then you could post to
You file a motion to be released without bond, because you've been in jail for this period of time and no charges have been filed against you.
How often does that happen?
Not very.
Not very often.
Well, the district attorney's office, when they're reviewing the charges, they know whether or not the person's incarcerated or not, okay? Because if you're not in jail, they've got more time to review your case than the ones where the people are still in jail. Those are the ones that they've got to do on a priority to make sure that someone isn't going to be released without bond.
Okay, all right. Another question here says, do bail bondsmen accept payments in installments?
Each bail bondsman is different, but it's very, very common from what I've seen for a bail bondsman to not collect the full 12% up front. They'll collect a portion of it and then allow you to make payments to them. But people will come in and say, you know, I've got to pay the bail bondsman this much money every week. And the thing about the bail bondsman is if you don't pay the bail bondsman the money that you owe the bail bondsman, they can surrender you back to the jail.
Really? So they can send you back if you do not make that payment. And do you ever get any of that money back?
Now, all the money you pay to the bail bondsman is their fee. And even if the charges are dropped or dismissed, you get none of it back.
You don't get any of that money back.
Sometimes what really is disturbing is when people come in to hire an attorney and they say, well, look, we know we need an attorney. It's a very serious charge, but we just paid the bail bondsman $5,000 and we don't have money at this time to hire an attorney. And that happens too.
Yeah. Well, so do you find that in so many cases people don't realize that they do have a choice?
They don't realize that there's another option other than calling a bail bondsman, which is calling a lawyer.
Calling a lawyer. All right. Another question says, if I am pulled over by a police officer, should I consent to a search of my vehicle?
Right, and that's a whole show all by itself on search and seizure as to whether or not. If they ask for consent to search, you can tell them yes or you can tell them no, but there are situations where they can get a warrant to search your vehicle anyway or bring out a canine, and it's a big question, not a little question.
We'll do that on another show, I guess.
We can do that on another show. And we have a question here about notice of attachment. What is a notice of attachment, and what happens if I receive a letter saying that I do have a notice of attachment?
You see, a notice of attachment is after you've been released from jail on some type of bond and you had a court appearance and you do not appear. When you don't appear, they issue an attachment for your arrest, and generally they'll send a notice. The court will send a notice to you to say you have missed an appearance in court. An attachment has been issued for your arrest. So at that point, you need to come back into court. You need to go back to court. I get calls all the time with traffic offenses where people missed their court date in traffic court and they have a letter saying you have an attachment.
Yeah, and I get calls from clients all the time who they didn't know they had a court date, they forgot they had a court date, then they get a letter saying there's an attachment for their arrest, and they're freaking out, and that's quite understandable. Number one, I want to know what you recommend people do when they get these letters, and number two, do they need to worry if they're visiting, if they're on a road trip across the country? Was that attachment on a national database where if they're stopped by a state trooper 3 states over, is it going to show up?
Some are and some aren't as far as which offenses go into a national type of a database, but I mean it's not uncommon at all for people to get arrested wherever you're stopped for a traffic violation, wherever you are. Say you missed court in Jefferson Parish and you're in Orleans Parish and you get pulled over for speeding and they run your name and, well, you have an attachment for missing a court appearance in Jefferson. Well, you're going to go to jail in Orleans Parish and wait for them to transfer you to Jefferson Parish. They're going to notify Jefferson Parish that we have one of your attachments in our custody.
You can't escape it.
It's not a good situation. If you've missed traffic court, that's more serious than you think.
If you get the notice of attachment, the advice is to call a lawyer and see what you can do.
And go in and make an appearance, get the attachment recalled, try to make sure if your bond, I mean, sometimes if your bond is forfeited, your bond can't be reinstated, you might have to post a new bond for criminal offenses.
And let me say, I know this tangentially because a lot of times my clients are involved in automobile accidents. Maybe the guest passenger is injured and they have a claim. The person who's driving has a traffic ticket. They went to court. Maybe they pled guilty, paid the ticket. Maybe they disagreed. They had an attorney. It seems like computer glitches happen all the time. And later on, they get a notice of attachment, but they went to court, and as far as they were aware, they even paid a fine. Do you see that much in Jefferson Parish?
Not error, but I mean, a lot of times, people some people have traffic records that are never ending, and you may have been to court, or you may have gone to court for it, but then you didn't finish paying the fine. And you didn't finish paying the fine, then you have an attachment for your arrest. It's not just not appearing in court.
We are completely out of time. Thank you so very much. We've learned so much in these last 2 shows. Appreciate your time. That is all that we have for this episode. Thank you so very much for joining us for the past 2 episodes, and many, many thanks to our guest, Joe Marino.
Thanks so much to Joe Marino III, and thanks to all of you for watching. Remember to send in your questions via Facebook, Twitter, and email. And go to johnredmannpoa.com to watch past episodes and to get more information. Also to hear us on iTunes. Thanks. We'll see you next week on John Redmann, Power of Attorney.